Welcome to the Dare to Know podcast. I'm your host, Fabian Corver. Today, we are joined by Matthew H. Kramer. Matthew H. Kramer is Professor of Legal and Political Philosophy at Cambridge University and a Fellow of Churchill College, Cambridge. He's the director of the Cambridge Forum for Legal and Political Philosophy, and he's the author of 16 books and the co-editor of 4 additional books. His work covers many areas of political, moral, and legal philosophy. His most recently published book is H.L.A. Hart, The Nature of Law. Today, however, we will focus on his book, Objectivity and the Rule of Law. I hope you enjoy this episode. The Dare to Know podcast is now also available on iTunes and Spotify. Please check out the links in the description of this video. Welcome to the Dare to Know podcast.
Thank you very much. I'm pleased to be with you.
Great. So maybe let's start off by discussing a little bit about your background. How did you get into philosophy and what has your philosophical journey been like so far?
Okay, well, I have been fascinated by philosophical issues since my early boyhood. I remember at the age of 7 engaging in a discussion with my mother about the nature of time. I remember that conversation quite vividly. And she recognized, having herself studied philosophy as an undergraduate, she recognized that I had quite a philosophical bent. So she provided me with a couple of anthologies of classic philosophical readings, which she had from her undergraduate days. And I naturally, at the age of 7, couldn't understand everything covered in those anthologies, but I certainly was gripped by a number of the selections. And about 4 or 5 years later, one of my older brothers brought home with him from his undergraduate studies some writings specifically in legal philosophy and also political philosophy. And among those were some excerpts from H.L.A. Hart's The Concept of Law. And I found those excerpts particularly fascinating. So I don't want to say from that day forward I knew that I was going to be a legal philosopher, but the trajectory did carry on pretty smoothly from there. I majored, that is, studied as a major subject, philosophy as an undergraduate, along with intellectual history and political theory, and then went to graduate school, both in philosophy and in law, and then pursued my PhD in legal and political philosophy. So that's how I entered the profession, broadly speaking. It's quite a long journey.
Yeah, very interesting. That's amazing. So today I kind of want to focus in particular on one of your books, which is titled Objectivity and the Rule of Law.
Here's the paperback.
There it is. Very nice. Yes. So it's a very interesting book. So maybe kind of starting off, you discuss several types of objectivity that are relevant for the philosophy of law. So you discuss in particular ontological objectivity, epistemic objectivity, and semantic objectivity. So can you maybe just lay out the picture a little bit? What are those different senses of objectivity and how should we understand that?
Right. I'll begin by saying that this book, which was published in 2007, Objectivity and the Rule of Law, was then followed a couple of years later by this book, more in 2009, Moral Realism as a Moral Doctrine. And this book does to moral philosophy, in a sense, what this book does with legal philosophy. That is, I explore this book is almost twice as long as the earlier one, but it explores at great length the nature of objectivity and morality, which overlaps with objectivity in law, but is also importantly different in some respects. I won't go into that here because we're discussing the earlier book, Objectivity and the Rule of Law. But in each of those books, I cover 3 broad categories of types of objectivity, as you've said, the ontological, the epistemic, and the semantic. Well, ontological objectivity, broadly speaking, pertains to what law is and what legal institutions are, what legal decisions are, and so forth. So they concern matters of existence and matters of the nature of things that do exist. And those things may be, and in certain respects are, independent of what people think about them or what anyone would think about them. Epistemic dimensions of objectivity pertain precisely to what people think and can know, and the ways in which people form beliefs about things, the ways in which people reach decisions, and so forth. And like ontological objectivity, epistemic objectivity is contrasted with various ways in which the formation of beliefs or the reaching of decisions would be subjective. So what unites the different types of objectivity is that each of them is contrasted with a type of subjectivity. Likewise, when it comes to the third main category, semantic objectivity pertains, roughly speaking, to the relationships between various statements or discourses or assertions on the one hand, and what is in the world on the other hand, where the world is to be understood expansively here. I'm not talking just about the material world. I'm also speaking about the normative world, which contains various legal norms, moral principles, and so forth. And so semantic objectivity would pertain to the relationship between various assertions or discourses or statements and the world, broadly understood. And so in each of these types of objectivity is a way in which the relevant dimension, ontological, epistemic, or semantic, is objective rather than subjective.
Very interesting. And when we then kind of focus specifically on ontological objectivity to start off, you identified three species of objectivity. Objectivity qua mind independence, objectivity qua determinate correctness, and objectivity qua uniform applicability. So how should we understand those species of objectivity within kind of the ontological domain?
Okay, well, in a nutshell, as the name suggests, mind independence concerns the degree to which, or the ways in which, certain phenomena are independent of what people think. And this is one respect in which the moral domain is quite significantly different from the legal domain, is that I argue in my later book that basic moral principles are strongly mind independent existentially, that is, in their existence. Their existence as such is independent of what people think. Whereas when it comes to laws, legal norms, laws are always dependent on what at least certain people think collectively, that is, legal governmental officials, the officials who operate a legal system of governance. And their attitudes and patterns of behavior and beliefs are constitutive of the operations of their legal system, and the norms that constitute that system are dependent on those attitudes and patterns of behavior and beliefs. And so nonetheless, the existence of each such norm is independent of what any particular individual thinks. At least in the vast majority of situations, that's true. And so they're what I call weakly mind independent rather than strongly mind independent. If they were strongly mind independent, they'd be independent of what officials collectively think as well as of what any individual thinks. But since they are dependent on what legal governmental officials, and to some extent also ordinary private citizens, believe and think, the mind independence of legal norms is only weak rather than strong. It's independent of what any particular individual believes, but it's not independent of the existence of such norms is not independent of what the officials collectively believe. I won't go into this because we don't want to make this too intricate, but there's another type of mind independence which I discuss, observational mind independence, which I'll just say very briefly pertains to the nature of each thing as it is believed to be. So it's not just the existence of each thing, but what is the content, what is the form, what is the character of each thing. And that I maintain is strongly mind independent. That's independent not only of what any individual takes the nature of the phenomenon to be, but also of what officials or any other people collectively take the nature of that phenomenon to be. So trying to explicate the distinction between existential mind independence and observational mind independence, I think would take too long for this podcast. So I can't go into any detail in that. I'm sorry if it's not entirely clear to some viewers, but it's a distinction which I develop at some length in this book and in my book on moral objectivity. Objectivity qua determinate correctness is pertains to the fact that, at least in relation to a wide array of questions about what is legally the case, there will be determinately correct answers. There will be uniquely correct answers, or correct answers within a very narrow range. Whereas if legal questions are indeterminate, in the sense that there are no correct answers or that any answer is correct, then there's no determinate correctness in that sense. There's no uniquely correct answer. There's no set of correct answers within a very narrow range. Either no answer is correct, or every answer, or virtually every answer, is correct if there's indeterminacy. So here, determinate correctness is contrasted with indeterminacy. And so this type of legal objectivity would be denied or impugned by legal skeptics, that is, skeptics who maintain that all questions about law, about what is legally the case, are entirely open-ended or indeterminate. And then finally, uniform applicability would relate to the fact that legal norms pertain to individuals not in a radically discrete manner, discrete manner, but instead across broad categories, often the citizenry as a whole. And so this is especially a concern in areas of the law such as tort, for example, where questions relating to, say, the requirements under the standard of negligence, that people act with reasonable care. The questions arise whether that requirement is to be understood in a radically individualized way, that is, pertaining to what is reasonable given each individual's capacities, or whether it's an objective requirement rather than a subjective requirement, in the sense that it cuts across individuals and requires a certain degree of care, regardless of what any particular person's abilities or capacities would enable that person to do. So that's another respect in which law can be, and typically is, objective rather than subjective. So those, in a really brief nutshell, which I'm sure has left a lot of unclarity, and I apologize for that, those are the three main types of ontological objectivity in law.
No, that's very helpful. And I think indeed, if you want to dig deeper, then you just have to read the book. So
that's right. Read the book. Buy multiple copies.
No, this is very helpful, and I think very interesting. And kind of moving on now to the epistemic objectivity. So can you run us also through those species, and again, how do they apply to law?
Right. Well, in this book, I delineate two main types of epistemic objectivity. One concerns the nature of the phenomena, legal norms, legal materials, and the other concerns the processes by which legal decisions are reached. So there's what I call trans-individual discernibility, which is a rather cumbersome phrase, just meaning the extent to which various legal phenomena are identifiable by persons in across large categories. So, for example, a classic instance of something that is trans-individually discernible would be an ordinary physical object. If people are looking at it from the same position, from broadly the same positions under the same epistemic conditions, the same lighting and so forth, then they'll see essentially the same thing. Of course, there are some contexts in which that won't be true, but by and large, that's true of ordinary physical objects. And there are many legal phenomena of which that's also true. That is, in any straightforward legal situation, in any so-called easy case, it will be true that people, anyone with legal training, anyone who is legally competent, will see that a certain answer to the question at issue is correct, and that any alternative answer would be incorrect. And so in that sense, large numbers of legal matters are trans-individually discernible. They will be viewed the same way across agents. They won't be viewed in highly idiosyncratic ways by the vast majority of people who are competent to assess legal matters at all. So that's what I mean by trans-individual discernibility. Impartiality is the other type of epistemic objectivity which I recount, and that pertains to the processes by which legal decisions or other decisions are reached. And so impartiality is naturally contrasted with partiality, and there are various requirements which I discuss. I won't go into all of them here, but one would be disinterestedness. That is, the requirement that a decision maker not have a direct stake in the outcome of the matter on which he or she is passing judgment. And that requirement, of course, is reflected in many aspects of legal institutions where legal decision makers are required to recuse themselves from controversies in which they do have direct stakes, or on which they have passed judgment in previous settings, and so forth. So disinterestedness is one feature. And then there are various others, I'll mention only one other requirement, which would be suitable circumspection in proceeding. That is, that one has to ensure that one is acquiring information from all relevant parties or from all relevant sources, and that one not proceed hastily or rashly. And so this aspect of impartiality, for example, would point to the key significance of lawyers in the operations of a legal system, because many relevant parties will not be adequately heard unless they are properly represented by lawyers. And so I maintain that a key feature of the rule of law then is the services of lawyers. Their services are essential in more than one respect. We'll come to another respect later, for the very existence of the rule of law in a society. So those are the two main types of epistemic objectivity which I consider.
Very helpful. And then moving on to the final one, namely semantic objectivity. So here you discuss one species of semantic objectivity in particular. Can you also lay out that final piece?
Yes. Semantic objectivity, as I've said, relates to pertains to the relationships between statements or assertions and the phenomena about which those statements or assertions are made. And this isn't the only type of semantic objectivity. I could have focused also on matters of meaning or reference, but the main type on which I focus in this book is truth aptitude. And what truth aptitude is, it means that a statement or assertion is properly evaluable as true or false. And so a statement can be truth apt while being false. A claim under the heading of determinate correctness, which I discussed earlier, a type of ontological objectivity. A further claim here is that many legal assertions are true, but this relates to a prior question. This semantic objectivity as truth aptitude relates to a prior question, which is whether legal assertions are properly evaluable as true or false at all. Because it's clear enough that some statements are not so evaluable. There are many examples of this, but one would be, say, interjections. If I say hello, that's neither true nor false. It's just not properly evaluable as true or false. It's not the sort of statement that is truth apt. Likewise, if I say shut the door, that might be evaluated as appropriate or inappropriate, but it's not properly evaluable as true or false. So-called imperatives are neither true nor false. So there are many types that in my book I recount a number of other types that are of assertion of statements that are not properly classifiable as true or false. And the question is whether any legal assertions are properly classifiable as true or false. And I maintain, in line with many other legal and moral philosophers, that numerous legal assertions are truth apt, that is, that they're properly evaluable as true or false. And so that's the type of semantic objectivity which I explore. I won't go into any of the details here. I rely on a certain approach that in modern day philosophy is characterized as minimalism, but I'm not going to go into any of that here. That would take us too far afield.
No, definitely. This is very helpful. And then kind of moving on to the second part of your book, which is really the part that I really enjoyed the most, was the elements of the rule of law. And here you kind of say that we can encounter the rule of law in two principal incarnations. And then you make a distinction between the jurisprudential conception of the rule of law and the moral political conception. So can you maybe introduce kind of these two ways of understanding the rule of law? And you also make the claim that rule of law in the moral political conception kind of goes beyond the rule of law in the jurisprudential sense. So could you maybe explain that?
Right. So the viewers can't see this, but the phrase "rule of law" differs from from the rule of law. In one of these phrases, the R and the L in the phrase "rule of law" are lowercase, that is not capitalized, and in the other use, the R and the L are capitalized or uppercase letters, and the rule of law with the lowercase letters is what I'm calling the necessary and sufficient conditions for the existence of a legal system, irrespective of the moral tenor of that system. And so what we're going to discuss imminently, Lon Fuller's 8 principles of legality, which I'll come to shortly, I take those to be understandable first as a set of necessary and sufficient conditions for the existence of any legal system. And then they can also be understood alternatively, but in many respects similarly, as an account of the procedural and formal aspects of a morally worthy, a liberal democratic system of law. And here we come to the uppercase R and L. And when they're understood in this way, the Fullerian principles, which we're going to encounter shortly, those Fullerian principles encapsulate a moral ideal, the ideal of liberal democracy, and they expound specifically the procedural and formal aspects of that ideal as they're embodied in the workings of a legal system. And I maintain in this book, the book, by the way, is divided into 3 quite long chapters. And the first of those chapters pertains to objectivity, which we've just been discussing. The second is where I expound these different principles of legality, both the rule of law lowercase, the rule of law uppercase. And then the third chapter explores some issues concerning the authoritativeness of law and how it is affected by the objectivity of law. And in that second chapter, where I expound the different features of the rule of law in each sense, I am drawing on these Fullerian principles. So why don't we move on to those right now?
Yeah, definitely. So indeed, can you please explain kind of Lon Fuller's kind of theory and framework that he was working with, and then also how you kind of draw on that work, but also how you maybe go a different direction than his theory necessarily goes?
Right. Lon Fuller was a professor at Harvard Law School in the middle decades of the 20th century. And he is certainly very well known in the common law world. I think somewhat less well known outside the common law world. But he made many contributions to the philosophy of private law and so forth. But his undoubtedly, in my view, his most important contribution lay in the first two chapters of a book that he first published in 1965 called The Morality of Law. He died, by the way, in 1978, and I didn't arrive at Harvard until 1981, so I never knew him. But his work is still very much influential in Anglo-American legal philosophy. And in chapter 2 of that book, The Morality of Law, he expounds his 8 principles of legality. Now, Fuller was an opponent of legal positivism, whereas I am one of the chief defenders of legal positivism. Legal positivism, in a nutshell, consists in an emphasis on the separability of law and morality, and an insistence in a number of different debates on the non-equivalence of legal requirements and moral requirements, or legal categories and moral categories, and so forth. But any legal positivist, of course, would readily accept that law and morality can be, and very frequently are, related as a contingent matter, even though they're not necessarily connected in the ways that are traditionally postulated by the opponents of legal positivism. So Fuller was an opponent, as I've said, of legal positivism, whereas I am a proponent, but I draw very heavily on Fuller's work on these 8 principles of legality. And that's because despite what Fuller thought, I do not take them to be indicative of any shortcomings in a conception of law which emphasizes its separability from morality. Quite the contrary, I take them to be indicative of the soundness of such a conception of law. But what is, I think, most interesting and makes Fuller's contribution to legal philosophy permanently valuable is that his principles are also a profound contribution to the exposition of liberal democratic political philosophy, because they provide us with an illuminating exposition of the main procedural and formal characteristics of the workings of a system of governance that adheres to the principles of liberal democracy.
Mm-hmm. Very interesting. So we can't go through all of the principles, but we can pick a few out there. So he has this 8 precepts of legality, and you mentioned that kind of the most obvious of the 8 principles of legality is that a system of governance has to operate through general norms. And I cite you, there can hardly be law without laws. So could you maybe explain indeed this principle in the jurisprudential thesis, but then also indeed explain how it gets this kind of moral political layer to it?
Right. As you say, we of course can't discuss all 8 of the principles that Fuller expounds. I'll just say that each principle delineates either some characteristic of legal norms, of individual laws, or some characteristic of the workings of a legal system. And so it's both the formal aspects of laws and the procedural aspects of the workings of legal systems. And it's those features that are encapsulated in Fuller's 8 principles. And it's precisely the fact that they are formal and procedural features, formal features of norms and procedural features of legal systems, that I think makes them universally applicable. They need not be confined to any particular jurisdiction. And so, as you say, his very first principle, and I think probably the most obvious principle, is what he calls the principle of generality. And that is that a system of governance operate through general standards that are not radically case-by-case directives, that is not radically context-specific directives, but which cover wide ranges of situations. Now, of course, any such general standard can be and often will be given effect through situation-specific directives. So if a policeman orders someone not to loiter in a certain area, and the policeman is acting under the authority of some general ordinance, for example, which prohibits loitering in various parts of a city, then the ordinance itself is a general norm, but the policeman's order to some particular individual is radically situation specific. So of course the workings of a legal system will often involve situation specific directives, but they also those workings also have to involve general norms if the system in question is indeed a legal system, because without laws there is not a system of law, and laws are precisely general norms. Of course they also have to be any adequate account of law also has to ascribe certain other characteristics to them, but among those characteristics would be their generality, in the sense that they cover wide ranges of situations and that they apply to wide categories of individuals. I should say, by the way, there can be some exceptions. There can be some norms enacted by a legislature or a local authority that apply only to a named individual, or that apply to a particular occasion. But those are clearly exceptional norms. The vast majority of norms that are operative in any legal system would not be radically individualized in their applicability in that way. The vast majority would be general in Fuller's sense.
And then how does it get like this political moral layer to it, so to speak? Yeah.
Right. Fuller himself, I think, writes quite illuminatingly on this matter, because he I won't go into all the details here, but he, I think, recounts some of the respects in which generality is a constitutional requirement in the United States specifically. And so there are constitutional limits on the ability of any legislature to enact a law that is directed against particular individuals, or that is radically individualized in its applicability to a situation and so forth. And Fuller, rightly, in my view, takes that constitutional requirement in the United States to be a moral requirement. It's a requirement that it's a requirement of procedural equality, for example, that people be treated as equals. It's a safeguard against nepotism or other types of favoritism and so forth. And so one clear respect in which the requirement of generality is a moral requirement is that it is at least convergent with, if not equivalent to, a requirement of procedural equality, which is a basic principle of liberal democracy. And so that's one respect in which this first principle of legality, the principle of generality, can be understood not only as something that has to be the case if a legal system is to be in existence at all, but also as something that has to be fulfilled if a legal system is to be morally worthy.
I see. And one thing I was wondering, and I'm not entirely sure if I'm confused about this, it was, let's say there is this moral political layer to this principle as well. Is it then still an open debate, kind of what the substance is of that moral political ideal? So, for example, I'm not sure if I talk about the notion of fairness, would that also be able to be put into this principle, or how would you respond to that?
Yes, in this book, and even more in the later book on moral realism, I discuss at some length. Yes, there are clearly many different versions of liberalism, and I mention a number of them here. Liberal political philosophy is a wide-ranging array of theories. There's, excuse me, there's no canonical position in liberal political philosophy. Undoubtedly, the most influential liberal political philosopher of the past century is John Rawls, but there are as many opponents of Rawlsianism as there are proponents. And likewise, even within Rawlsian political philosophy, there are many different versions. So liberal political philosophy is a rich, multifaceted array of political philosophies. And within that rich, multifaceted array, these principles could nonetheless be incorporated by any of the relevant theorists. And so and that's precisely because, as you suggest, the principles in their moral rendering, that is the rule of law, uppercase R, uppercase L, the principles constitutive of the rule of law in that moralized sense can take on many different substantive understandings. I think that is one of the great virtues of Fuller's principles. It's something that Fuller himself emphasized. He emphasized that he was tracing the formal characteristics of norms, the procedural characteristics of legal systems, and he was abstracting from what he called the external morality of law, by which he meant the substance of legal norms. And I think that's one of the great virtues of Fuller's principles, and that virtue is reflected in their moralized rendering as much as in the jurisprudential rendering.
Very interesting. And when we move on to another principle, so he talks about the principle that is related to prospectivity. So again, can you elaborate on this, how this renders in the rule of law, and the rule of law with capital RL?
Right. Prospectivity or non-retroactivity relates to the fact that legal norms characteristically, again, there can be odd exceptions, but they are clearly exceptional, that legal norms prescribe how people are to behave henceforth, and not how people were required to behave in the past. So they don't state that yesterday you're required to do such and such because yesterday has already come and gone. It may be, of course, that the same norm that is applicable today was applicable yesterday, in which case yesterday it did prescribe how people were to behave. But today it's no longer prescribing how they're required to behave now. It's offering guidance to how people are to behave now or in the future. And so that's prospectivity or non-retroactivity. Of course, a norm can have retroactive applications. No one denies that, and indeed Fuller recounts a number of respects in which retroactive applications can be salutary and are often quite common. But those retroactive applications are not the exclusive or predominant function of the norm. Its predominant function is to offer guidance now and in the future. And that's the sense in which they're prospective.
And again, like, so if I'm not missing this, that would be kind of the formal characterization. And then how would it get, again, its moral political load into that principle?
Right. Well, again, Fuller, I think, is quite illuminating on this point, even though Fuller doesn't accept my distinction between the two ways of understanding his principles. He takes them to be inherently moral principles. I think that he was wrong about that, but still, what he says about their moral character can often be illuminating for a discussion of the moralized understanding of the principles, even though I think that that's not the only understanding of them. And so the prospectivity would relate to the fact that if legal norms were solely or predominantly retrospective or retroactive and not prospective, then first of all, they wouldn't be offering guidance that is essential for people to know where they stand, and so they wouldn't be giving people proper notice of the legal implications of their conduct, which is clearly morally problematic. It's also jurisprudentially problematic because a legal system that doesn't offer such guidance isn't effectively operating as a legal system. But it's morally problematic, clearly. But likewise, if the requirements attaching to people's behavior are being changed retroactively, then people are being held to standards which they couldn't reasonably be aware of at the time they were acting. And again, that is legally problematic, morally problematic. And so in a number of respects, this requirement of prospectivity is a moral requirement as much as a jurisprudential requirement.
Very interesting. And before moving on kind of to the third principle I want to discuss, just focusing a little bit on Fuller's complaints. Let's say he was here today, what would he argue against you of you trying to kind of separate the moral matter from the jurisprudential matter? Like, what would be his best argument?
Okay, well, I don't really want to try to construct arguments for him because I feel that the second chapter of his book, The Morality of Law, is a major and permanently valuable contribution to legal philosophy, whereas I feel that the subsequent chapters where he attacks legal positivism are just extremely weak and really quite embarrassing. So I feel that the latter half of his book, the second chapter in the book is by far the longest chapter, and it's, in my view, by far the most important chapter. I think the latter half of his book is best ignored, though I have, in fact, engaged in an extensive critique of it in a book of mine called In Defense of Legal Positivism. The third chapter of that book is a lengthy set of ripostes to Fuller's anti-positivist stance. And I believe that response to Fuller is fully consistent with my much more favorable assessment of him in this book, because he took his principles of legality to be antithetical to legal positivism, whereas I take them to be perfectly compatible with legal positivism and indeed an enrichment of legal positivism. So I don't want to try to construct arguments on his behalf because I'm so profoundly unsympathetic to the arguments which he did present, that I think it would be a bit unfair for me to try to speak in his voice.
No, that makes sense. Okay, then we'll move on to the fifth principle that you discussed, the fifth principle of legality, and this one relates to conflicts and contradictions. You state that more than some of the other principles of legality, this principle of non-conflictingness and non-contradictoriness differs importantly in its moral political guise from its jurisprudential counterpart. So can you maybe elaborate on this? What's so special about this one?
Right. Well, we'll take here. There are some other types of moral conflicts as well, but legal conflicts between legal duties. There are some other types of legal conflicts between legal duties as well, but the type here that we'll consider would be the simplest example, where someone is under a duty to do X, whatever X may denote, and simultaneously under a duty not to do X. So that would be a conflict between legal duties, and such conflicts can and do arise. Fuller recounts some of them, though he conflates them with contradictions. I won't go into that here, but such conflicts can and do arise, the point is that the conflicting legal duties can and do coexist, but they can never be jointly fulfilled. One and only one of them will be fulfilled at any given time, because the fulfillment of either of them entails the non-fulfillment of the other. Now, the reason I take this principle to be special in a way, as far as its moralized rendering, is that in its jurisprudential rendering, the rule of law, lowercase r, lowercase l, in its jurisprudential rendering, there could be pervasive conflicts between duties within a legal system, where nonetheless that system would provide guidance to people on how they ought to behave, because each duty will have to be remedied, and if the heaviness of the remedy for breaching one duty were significantly different from the heaviness or onerousness of the remedy for a breach of the other duty, then people would still have determinate guidance on how they ought to behave. They ought to comply with the duty that carries the less severe or less onerous remedy attached to its breach. And so there would be pretty straightforward guidance in such a legal system. But if we view the matter from a moral perspective, where regardless of how each person behaves, he or she will be in breach of a legal duty. Granted, there might be a determinately correct answer to the question how he or she ought to act. He or she ought to fulfill the duty that carries the less stringent penalty for, that carries the more stringent penalty for its breach. Still, regardless of how he or she acts, he or she will be breaching a moral duty and will be required to come up with a suitable remedy, to pay compensation or to serve time in prison or whatever the remedy may be. And that would clearly be morally problematic if, regardless of how people were behaving, they were being subjected to penalties. And if this situation weren't just exceptional as it can be, but if this were pervasive, if this were commonplace, it would be deeply problematic. So a situation in which a departure from the principle of non-conflictingness, this fifth principle that Fuller recounts, would be jurisprudentially feasible, would nonetheless be morally profoundly problematic. And that's what I find interesting about this fifth principle, is that the relationship between the jurisprudential understanding of it and the moralized understanding of it is there's a greater division between the two here than in regard to any of the other principles.
I see. Yeah, there's a lot more on the line from the moral perspective, basically. Okay, that's very interesting. So in your book, you also discuss that the framework we been discussing and these principles we've been going through, that we kind of should see that as necessary threshold conditions for the existence of any legal system. And you also kind of contrast that with another legal philosopher that has characterized this framework as an archetype. So maybe can you explain indeed how those views differ, what the alternative view is maybe of looking at this framework, and why you think that your framework fits better?
Right. The view of the 8 principles as an archetype was propounded by my erstwhile colleague, Nigel Simmons, who retired a couple of years ago. And broadly speaking, what he means is that he took the Fuller's 8 principles of legality to be a template of perfection, such that a legal system that perfectly realizes every one of those 8 principles is an ideal legal system. And he uses the example of a geometric definition. Take the definition of a circle as the curve constituted by the full set of coplanar points equidistant from a common point. That's the mathematical definition of a circle. And Simmons took the Fullerian principles of legality to be relevantly similar. An ideal legal system would be a system that fulfills or realizes every one of those principles fully. Lon Fuller himself warned against this way of understanding his principles, and I think that he was entirely correct to do so. That is, he warned against it in part because the perfect fulfillment of some of the principles would exclude the perfect fulfillment of some of the other principles. So I'll offer only one brief example here, and that would be, let's take the first principle, the principle of generality, which we've already discussed, and then another principle, the fourth principle, which we haven't yet discussed, the principle of clarity. Well, to realize maximally the requirement of generality, the law would have to be dauntingly abstract. So it might simply prescribe to people that they act reasonably, and that would be the only legal standard in force. But if there were a legal system that tried to operate in that maximally general way, the requirements incumbent on people, legally speaking, would be radically unclear. Mm-hmm. And so the full realization of the principle of generality would preclude the full realization, and indeed would involve the radical departures from the principle of clarity. And so one reason I think Fuller was right to reject Simmons's understanding of the Fullerian principles is that it's an incoherent understanding. But there's an alternative understanding which Fuller articulated, which I think is manifestly superior, and that is that the principles are best understood in two ways. One is that each principle lays out a necessary threshold condition for the existence of a legal system. I'll explain that in a moment. And then each principle is likewise aspirational in that at least up to a certain high level, the greater the realization of each principle, the more solidly legal in character is the workings of a system of governance, or are the workings of a system of governance. So as far as a threshold condition, what I mean by that is that if any one of Fuller's 8 principles is contravened comprehensively or almost comprehensively, in the sense that it's never fulfilled or almost never fulfilled by any legal norms, then there's no legal system in existence at all. Mm-hmm. And so in precisely that sense, each principle lays down a certain threshold. It's not a specifiable threshold, of course. Fuller himself emphasizes this. Mm-hmm. There's no talismanic point where we can say, oh, that's just enough for the existence of a legal system. But what has to be the case, nonetheless, is that each principle of legality is satisfied to quite a high degree, or else there's no legal system in existence at all. Mm-hmm. And precisely in that respect, each principle specifies a necessary threshold condition for the very existence of a legal system. But then each principle, likewise, is aspirational in the respect that I've indicated, and that up to some unspecifiably high level, the greater the realization of each principle, the better that system of governance is as a legal system, in the sense that it operates more straightforwardly, more clearly as a legal system. And so these two aspects of the Fullerian principles, which were emphasized by Fuller himself, mm-hmm. I think are a far superior way of understanding them collectively.
Mm-hmm. That's very helpful. And then in the final part of your book, which I will admit wasn't the part I fully understood, so this might help. You discuss kind of one of the issues you discuss is the issue of indeterminacy and how it is incompatible with law's moral authoritativeness. So could you maybe explain to me what issue were you discussing there? What's the relevance of it? How are you bringing these different parts of the book together? And just, yeah, if you could lay that out, that would be extremely helpful.
Right. Well, as I've already said when we were discussing ontological objectivity, indeterminacy here is contrasted with determinate correctness. And so when I talk about indeterminacy, I'm talking about the fact, or the putative fact, that certain legal questions do not lend themselves to any determinate answers, mm-hmm. either in the sense that no answer is correct or in the sense that every answer is mm-hmm. correct. And so there are no determinately correct answers to certain legal questions, or so the claim would be. And so in the final chapter, the third chapter of this book, sorry, I had it the wrong way around. In the third chapter of this book, I draw upon the first chapter, which explicates the different aspects of legal objectivity, and the second chapter, which explicates the various aspects of the rule of law, so covering the two portions of the title of the book. And I bring them together in a discussion of law's authoritativeness. That is, what is the bearing of these different aspects of these different elements of objectivity on the authority of law? And specifically, as you say, I'm considering this in relation to indeterminacy and claims about the insusceptibility of certain answers to being answered in determinately correct ways. And again, I can't go through all the issues that I discussed there, but broadly speaking, the claim would be that insofar as indeterminacy is rampant rather than confined to certain localized contexts or exceptional contexts, the authoritativeness of law is diminished. And likewise, the capacity of law to provide guidance is clearly diminished. Now, on the one hand, unlike Ronald Dworkin, a major contemporary legal philosopher who died in 2013, Dworkin, throughout his career, but especially in the early years of his career, maintained that every legal question is susceptible to a determinately correct answer, a uniquely correct answer. He wrote a famous essay called One Right Answer. And no one, or virtually no one, goes as far as Dworkin in that respect, and I do not. But I nonetheless do share his view that many, indeed most legal questions are answerable in determinately correct ways. And I think that some legal questions that are often viewed as not so answerable are in fact. So there, I go quite a long way with Dworkin, but I don't go all the way with him. And so, like other legal positivists, I would certainly take the view that there are cases that arise in which there are no determinately correct answers to the points at issue. And those cases don't threaten the existence of the rule of law. They don't threaten the moral authoritativeness of the rule of law, provided that they are not typical or pervasive. If they're typical or pervasive, then a system of governance is not operating properly as a legal system at all, and it likewise does not partake of authoritativeness as a system which provides citizens with adequate reasons to understand the legal implications of their conduct. But if those cases are instead exceptional, then there's no detrimental effect to the existence of a legal system or to its moral authoritativeness. And so indeterminacy, clearly both the nature of indeterminacy and the extent of indeterminacy would have major bearings on questions about the authoritativeness of law. Now, there are different types of indeterminacy. I'm not going to go into all of them here, but the main types that I can, I'll mention only one here. The main type that I consider in the final chapter of this book would be simply a situation in which no answer is any more, has any greater claim to correctness than any other answer. So it's the type of situation in which no answer is legally correct, or in which every answer is legally correct, but there's no greater claim to correctness for any answer. And that's the main type of indeterminacy I consider in the chapter. There are other types which I explore in other parts of the book, but when we're considering questions about law's authoritativeness, that's the main type I consider.
Very interesting. So yeah, Professor Kramer, thank you so much for being on the podcast. I really enjoyed it. And do you have any parting words to the audience?
Well, again, I thank you very much. I'm very grateful for having had this opportunity to discuss these matters. And I would say that I'll just mention, since I've talked about my own books here, I'll mention a few other books that might be helpful for people who want to explore these issues. Naturally, of course, I recommend my own books first and foremost. But and by the way, Objectivity and the Rule of Law is written to be accessible to undergraduates. And certainly, I think the first two chapters are. The third chapter, as you said, is a bit more advanced. But but I can recommend it to undergraduates as well as to others. I'll mention two other books that I think would be useful. One is a collection of essays edited by Brian Leiter, Leiter, called Objectivity in Law and Morals. And there are a number of really rewarding essays in that book. Some of which I mention in my book, Objectivity and the Rule of Law. And then a slightly older book by Kent Greenawalt called Law and Objectivity, obviously fairly close to the title of this book. And that book, though I disagree with a number of aspects of it, nonetheless, I think contains some really illuminating insight. So those are a couple of other books that I would recommend to anyone who would like to explore these issues.
Well, great. Thank you so much. So this will continue. So thank you for the recommendations and thank you for being on here.
Thank you very much.